oppression. This joint event is being organized and collaborated with Salam for Democracy and Human Rights and Institute of Statelessness and Inclusion and MENA Statelessness Network. During this event, we will launch a very comprehensive report under the same title. This report, you can find it in Salam for Democracies and Human Rights website. And at the same time, it is in Arabic and English language. Today, focusing on the issue of the revocation of nationality and mainly Bahrain as a case, we're going to elaborate on this case with the many different ideas, and we will bring up with us some experts, some human rights defenders, and some representatives of the NGOs who well studied. At the same time, they will tackle it from different angles. And in the meantime, we will hear from some victims how they lived with this issue after their nationality has been revoked. If we can start with the short clip, which is going to summarize the topic of this event, then after that we will follow to hear from our colleague Shaima, which she's going to present the report and launch it. So first, let us see the short clip on the arbitrary revocation of nationality in Bahrain, a tool of oppression.
Revocation of nationality, rather than providing a pretext for security, destabilizes the state and poses a threat to people's safety and personhood. A corollary consequence of revocation at the international legal framework is a denial of positive enjoyment of rights. From 2012 and 2019, a total of 985 people had their nationality taken away based on a court order, a royal decree, or a ministerial order, since the king restored citizenship for 551 people in 2019. The total number is now 434 people who are still enduring the effects of the citizenship stripping. Revocation of nationality, rather than providing a pretext for security, destabilizes the state and poses a threat to people's safety and personhood. A corollary consequence of revocation at the international legal framework is a denial of positive enjoyment of rights. From 2012 and 2019, a total of 985 people had their nationality taken away based on a court order, a royal decree, or a ministerial order, since the king restored citizenship for 551 people in 2019. The total number is now 434 people who are still enduring the effects of the citizenship stripping decisions. Bahrain has been using the revocation of nationality as a tool of oppression by targeting human rights and political activists, members of the opposition, journalists, religious scholars, academics, and even those who are not affiliated with political or religious movements. Most of the victims who were still in Bahrain at the time of their citizenship being revoked were persecuted and deported for living in the country illegally, as shown in the cases of Masoud Jahroumi and Ibrahim Karimi, on the basis that the government had the complete right to decide what damaged the dignity and stability of its internal and external security, and that the revocation of citizenship is a last resort. Bahrain's revocation of nationality is a direct breach of the country's obligation under international human rights and humanitarian law. Bahrain should take active steps toward reforms as we make the following recommendations to the government of Bahrain. Immediately end the practice of arbitrary citizenship revocation. Reinstate full citizenship to the hundreds of nationals whose citizenships has been revoked since 2012. Repeal Article 10 of the current nationality law, which allows the Minister of Interior to revoke nationalities.
And as I indicated, there's a short clip as an introduction to our event for today. And as the report indicated, the arbitrary revocation of nationality is being human rights violations in Bahrain, a very grave human rights violations in Bahrain. as report indicated, it started in November 2012, yet we have as around 434 Bahraini still their nationals been revocated. In the same way, many of them without any judiciary verdicts, or it was not through any judiciary process, either through the Ministry of Interior or a decree by the king. Yes, after some legislation been amended and a few nationality has been stripped through court orders. Now I like to welcome our colleague Shaima Al-Qahs. She is a researcher in Salam DHR, and she will launch our report, which is the same title of the event, Arbitrary Revocation of Nationality in Bahrain, a Tool of Oppression. This report is jointly being drafted and being amended by ISI, Institute of Stateless Inclusion, and our other partners, MENA Stateless Network, Hawiyati. So Shaima, please go ahead and yes, start launching the report. Go ahead, please, Shaima.
Oh, sorry about that, everyone. Okay, hi, everyone. What I was saying is thank you, Jawad, for that introduction. And just to say that the report has been aptly titled, which is Arbitrary Revocation of Nationality in Bahrain, a Tool of Oppression. And so the report looks at the state practice of nationality revocation in Bahrain after the Bahraini uprising in 2011. The highest total number of Bahraini nationalities that have been revoked was at 985, and today 434 remain stateless as a result of that. So Bahrain is a small country situated in the Gulf, and it had gained independence from the British in 1971, and under the monarchy of Sunni Khalifa family, a majority Shia Bahraini population, and the sectarian divide, as well as the delegation of the Shia population as a second-class citizen, political and social strife in the country has been ongoing since the 1920s and has also been in the 1990s, as well as culminating a decade ago, 2011, after the Arab Spring inspired the Bahraini people to take to the streets and demand for their own human rights, for their enshrined human rights. And it also happened 10 years after the passing of the National Action Charter, which had promised so much reform for the people. But so as a result of that protesting, which was all peaceful, by the way, there had also been a lot of quelling of it by the royal family, and this widely detailed in the Basuni report, which was commissioned by Khan himself, published by the BICI, and they came to the conclusion that the protesters' claims of protracted and intense torture, sexual assault, and psychological imprisonment of Bahrain and by state actors were all proven to be true. But with the findings of the report, it was actually only the protesters who had suffered a sort of consequence as a result of the actions that they had taken. So the aggressive actors themselves never faced any convictions, and all enjoy a culture of impunity. And so one of the ways that this was manifested was through the revocation of nationality. And so the report details some cases, but overall tells you the numbers of the revocation of nationalities that has occurred since 2011 till 2019, and as stated, the highest number being 985. But before we go on to there, talking about nationality and statelessness. So though a state has the right, of course, to decide the content and the pursuit of nationality, in itself doesn't act outside of international law and what international law states, and as a result, there is a void and protect against statelessness, an obligation that was not followed by the Bahraini government of nationality. And so the report details how international law works in that sense with the act of revocation, as well as the Bahraini government's veneer of validity to what it did by citing national security threats as a reason of revoking someone's citizenship. And so international law also takes a look at that in the report. We also go into two cases of nearly 1,000 cases of such an action. One of them being a case of Dr. Mr. Jahromi, who will be speaking hopefully today about that as well. But before we go on to talking about the actual evolving Bahraini national legislation and how it changed in order to offer power to the Minister of Interior without any judicial oversight into revoking nationality, one important thing stateless is also to make them illegal in a sort of in a way that they can't stay in that country anymore. So their residence itself is illegal, and as such, many Bahrainis have been forcibly deported from their country as a result of that. So that of course increases this whole other problem that we have currently, which is the problem of refugeehood and asylum as a result of statelessness. And so the evolving Bahraini nationality law, though the report itself does go into a lot of detail, and I won't be able to go into all of it right now. But one thing to take note of is that the current decree is based on Decree Number 16 of 2019, amending the Bahraini nationality law of 1963, which gives the full power of revocation to the Minister of Interior. Initially, the revocation had already been in the king's hands, but then it would pass down to all and empower the power of the criminal courts, as well as very vague languages would more validity to acts of revocation. So, for example, when we look into which of course we go into more detail in there. But for example, if we look into the 1963 nationality law, the initial nationality law of Bahrain, in Article 10, it, like I said, gives the paragraph C of the article very vaguely and broadly suggests that if someone causes damage to state security, then they must have their nationality revoked. With that vague language, it means that there are more cases that can kind of be justified to revoke someone of their nationality. This was then substantiated in Decree Number 20 of 2013, which amends law number 58 of 2006 from terrorist acts. So even there, terrorism acts themselves have become vaguer. The language used to define what they are has become broader. And so I think it would prime the mind into thinking that progressively asking for a way of destabilizing national security, and as such would make someone liable to justifiably lose their nationality, according to the Bahraini government, and powered by the criminal courts, who had used that law to strip hundreds of Bahrainis of their nationality. And then that was also amended in Law Number 20 of 2014, Law Number 21 of 2014, which gave more power to the Minister of Interior, took it away from the king, but would still, of course, need ratification by the king. But here, the language is also still extremely vague, and then it's now, rather than cause damage to the state, it's more so if you cause damage to the interests of the kingdom, or if you act in a way that is deemed to be disloyal against it. But this was also, again, changed in 2019, and now cabinet can work without the ratification of a decree. So the report goes into detail a lot with a lot of those articles, as well as into the statistics of how a lot of the revocations have occurred throughout the years. Many of them occurred in a way that was actually of the changes that had been occurring with the Bahraini legislation. And of course, the report concludes with many recommendations given to the state of Bahrain, as well as the wider international community, in making sure that statelessness or revocation of nationality does not lead to statelessness, for people's nationality to be reinstated again, and to not use national security as a way to nationality. Thank you.
Thanks a lot, Shema. And as I indicated, the report fully, you can find it in our website. It is in English, and shortly we will post the Arabic version of the reports. And I like to thank ISI for them to circulating the report and their newsletter. For sure, so many part of it, we try to focus on it in different coming events. Let me here take a chance to indicate that the case of revocation was part of our focus since long time, since 2012, when the first groups, which I was one of them too, where my nationality has been revoked. And now we have one special website called Ana Bahraini, which we are considering it as a reference website, where we can find whatever is being written, published, or any references related to the statistics in that website, anabahraini.org. You can find it. Now, next, I like to give a chance to our colleague and victim of revocation of nationality, Dr. Masoud Jahrami, who his nationality has been revoked arbitrarily in January 2015 by decree. Dr. Masoud is a PhD holder and researcher and academic, and now he is in exile. He is in Lebanon currently since he been forcibly deported from Bahrain. So, Dr. Masoud, please go ahead.
Hi, everybody, and good evening. I am Masoud Jahrami, a Bahraini academician and victim of human rights violation in Bahrain, detained for 5 months in 2011, became stateless on 31st January 2015, and consequently deported from my country on 7th March 2016. Thank you, dear Jawad Ferouz and other organizers of this event for giving me this opportunity to advocate other victims of nationality revocation in Bahrain. I should thank all organizations and individuals who work hard trying to verify and stop human rights violations in Bahrain. Unfortunately, the Bahraini authorities' strategy, rather than terminating the violations and instead of showing the individuals to practice their rights, is putting strong efforts and investing huge budgets in public relations and establishing fake organizations in order to cover the truth and whitewash the human rights violations. However, arbitrary nationality revocation cases in Bahrain clearly illustrates their strategy. Tonight, I am going to share with you my own case, divided in 3 phases. First, I'm going to talk about my record and experience with the National Security Service Department. Then I will explain how I received the nationality revocation order and its related issues. And finally, I will talk about how I was deported from Bahrain. The period between 15th March to 14th April 2011, I, as thousands of Bahrainis, was reading and hearing and even watching news about different aspects of Bahraini security and military forces' attitudes and treatment with individuals. But on 14th April, myself and all my family members became victims and direct witnesses of those unaccepted attitudes. 2 hours past midnight, when all family members were sleeping, our family residential compound got surrounded and attacked by several police jeeps without showing any warrant or to enter the compound. That moment was just feeling a Hollywood movie, picturing how US Army attacks terrorist hideout. Just imagine such a huge number of security forces aggressively attacking a residence of a 5 villas in which an old mother, about 80 years old, and 1 month old infant, brothers and sisters whom are academicians, doctors, teachers, and well-known businessmen, were leaving. Yes, they had us to arrest me. At that midnight of April 2011, which affected all our lives. Since that night, I recorded and reported various kinds of violations our family faced. From the first moment they attacked our compound until the day I was released from prison. In detention, I was continuously tortured, physically and psychologically, without knowing what my accusation was. Almost after 4 months of my arrest, when I was visited by a member of BICI, I knew that the only charge against me is participation in an Mr. Ata Hinaydi, a Palestinian, told me, your case is one of the darkest cases in the service department. He clarified, they have decided to arrest you without having any clear, strong reason. And when there were no charges against you, they were not pleased to release you. So they handed your case to the court with one single charge, which is participation in an unauthorized rally. Subsequently, after 10 months, when the final court decision was issued, I could manage hardly to return back to my normal life activities and was resumed in my academic profession and continued for almost 3 years in Ahliya University. However, on January 30, 2015, while I was having lunch with my family in a restaurant, it was on Saturday, I received a WhatsApp broadcast. Nationalities of 72 Bahrainis are revoked through a king's decree. When I clicked to view the names, I was shocked. My own name was the third in the list. It was not only a strong shock to us, but to everybody or everyone. No one could find any fact or reason behind such decision, unless that I did not participate in the 2014 parliamentary elections. Of course, based on this decree, I became stateless, and the Bahrain treated me as a foreigner with illegal residence in this country. They forced the university board to fire me, and the passport, of course, the passport department handed my case to the court for issuing the deportation order. The court took almost 1 year or more than 1 year. On 6th March 2016, the final court decision ordering to deport me from Bahrain. Starting early morning, I received continuous calls from the passport department to visit them. As I was guessing their scenario, I delayed attending there until afternoon to stood by sun. I reached there to the passport department. They asked me to choose my exile destination. I am going to UK. The guy said, do you have a visa for entering the UK? He said, okay, you have to choose in Lebanon, Algeria, or Turkey. I replied, if I am forced to choose from this list, then I will go for Lebanon. Then he said, okay, are you going to issue your ticket? I said, definitely no. You are forcing me to leave my country. Choice. You have to offer me a ticket. Immediately after this short discussion, they drove me to the airport and I was deported to Beirut via Qatar Airline. And still I am in Beirut. Thank you.
Thanks a lot, Dr. Masood. As he indicated, this is one of the sad stories that we hear from through the similar process. Out of around 1,000, I can say that more than 100 been facing such case, arbitrary revocation of nationality, so sudden demand of the deportation and forcible deportation, and yet is being given for such unhuman acts being made by. For sure, these cases, we are documenting it just to give indication that this human rights violation is not according to the law. It is just purely as a tool of oppression, as we indicated in our report and the title of this event. Next, I like to introduce Kaya, a researcher in ISI, Institute of Stateless and Inclusion. She will speak mainly on the principle on deprivation of nationality as a national security measures and input. Let me mention here, ISI launched a very excellent and successful career on the principles on deprivation of nationality. Yes, Kaya, you can start.
Thank you so much, Jawad. I'm very proud that we're launching this report on arbitrary revocation of nationality in Bahrain today, and very grateful for the fantastic cooperation on this with Salam for Democracy and Human Rights and the MENA Statelessness Network. And a special thanks to Salam DHR for organizing this event today. I'm this group of speakers and will focus my contribution on the international legal framework applicable to nationality deprivation. As the joint report on arbitrary revocation of nationality in Bahrain demonstrates, nationality is employed as a tool of oppression. Nationality is thereby instrumentalized by the state, which is quite the opposite of nationality being considered as a human right as proclaimed in Article 15 of the Universal Declaration of Human Rights. By Bahrain, but also by other states around the globe, nationality is treated as a privilege that can be taken away, and those who are affected by citizenship stripping face acute human rights deprivations as a result. It is this trend of instrumentalization of citizenship that inspired the Institute on Statelessness and Inclusion and other organizations to initiate a year of action against citizenship stripping, which aims to draw attention to the issue and encourage states to align their laws, policies, and national legal obligations as synthesized in the principles on deprivation of nationality as a national security measure. As the international law, and in particular human rights, has evolved, a number of key principles have been recognized as limiting state discretion in setting rules and criteria in relation to citizenship. Indeed, of citizenship, but international law limits the state's powers in this regard. There is a wide range of well-established and developing international law standards which states are obliged to uphold when considering the interest or the implementation of existing powers to deprive nationality of their citizens. These have been brought together in the principles, as mentioned, and these restate or reflect international law and legal standards under the UN Charter, treaty law, customary international law, general principles, judicial decisions, and legal scholarship, as well as regional and national law and practice. The principles were developed over a 30-month research and consultation period with input from more than 60 leading experts in the fields of human rights, counterterrorism, refugee protection, child rights, migration, and other areas. They aim to provide important guidance on the question of deprivation of nationality from a wider international law perspective, accompanied by commentary that provides a more detailed analysis of the international law basis that underpins the principles. The principles are freely available online and have been translated into Arabic, French, Russian, and Spanish. Let me now turn to the content of the principles and highlight the key international principles of relevance. When considering all international standards on the issue together, it becomes clear that state discretion in relation to deprivation or revocation of nationality is subject to the individual's right to nationality, the prohibition of arbitrary deprivation of nationality, the prohibition of discrimination, and the obligation to avoid statelessness, something that was already noted in an earlier presentation. Also, the impact of nationality deprivation on the enjoyment of other human rights, humanitarian and refugee obligations must be taken into consideration when assessing the legality of nationality deprivation measures. Such measures must furthermore comply with due process safeguards and, of course, the right to a fair trial. Please allow me to highlight some of these principles further. So the avoidance of statelessness has been considered a fundamental principle of international law and is acknowledged as an obligation of international customary law even. States that consider depriving an individual of nationality are thus limited in their discretion by this obligation, and the burden is on the depriving state to ensure that statelessness does not result from such an act. The consequence of the duty to avoid statelessness is therefore deprivation cannot be lawfully pursued if it results in statelessness. The prohibition of discrimination, as articulated by principles, says that the state does not deprive any person or group of people of their nationality as a result of direct or indirect discrimination in law or practice on any ground prohibited under international law, which may impact language, religion, political or other opinion, national or social origin, ethnicity, property, birth or inheritance, disability, sexual orientation or gender identity, real or perceived status, characteristic or affiliation. This is, amongst others, based on Article 9 of the 1961 Convention on the Reduction of Statelessness, which prohibits the deprivation of nationality on ethnic, religious or political grounds, even if statelessness does not result from this. Furthermore, the prohibition of arbitrary deprivation of nationality out in the principles based on Article 15, paragraph 2 of the Universal Declaration of Human Rights. It means that any measures to deprive nationality must be founded on a clear legal basis, must serve a legitimate purpose, must be proportionate to the interests protected, and needs to install procedural guarantees which must be respected, allowing the concerned to defend themselves before an independent body. International law also stipulates that nationality deprivation must be necessary, and thereby the least intrusive means for achieving the stated legitimate purpose must be chosen. As mentioned earlier, the impact of nationality deprivation on the enjoyment of other human rights must be considered to determine the proportionality and lawfulness of such measures. These other human rights considerations include the following human rights: the right to enter and remain in one's own country, meaning that all people have a right to enter, remain in, and return to their own country, and that states are prohibited from expelling their own nationals. The prohibition against torture and cruel, inhuman, and degrading treatment or punishment, whereby nationality constitute cruel, inhuman, and degrading treatment or punishment, particularly where it results in statelessness. And for instance, the right to private and family life and the rights of the child, in particular, every child's right to acquire a nationality in the best interests of the child. So other human rights and humanitarian considerations must be taken into account when determining the proportionality and the lawfulness of deprivation measures. The principle is to the use of proxy measures, meaning that states must not use powers to deprive nationality for other stated purposes, including fraud, with the ulterior purpose of depriving nationality for national security reasons. Deprivation of nationality for ulterior motives or as a means to an end without the necessary due process guarantees does not meet the international law standards relating to due process and on arbitrariness more broadly. Measures that cause nationality, such as restricting people's ability to leave or enter their country or limiting access to travel documents to that end, may also constitute arbitrary deprivation of nationality. The principles and the commentary, of course, contain further principles and more detail on the principles that I've highlighted. It provides a deeper analysis in case you want to learn more. As the report shows, Bahrain's revocation of nationality is a clear violation of its obligations and standards. This report and the event also demonstrate the severe consequences of nationality deprivation and the abuse of human rights that's accompanied by this. This is exactly why there are strong safeguards against nationality deprivation and international obligations, which we recommend the government of Bahrain to comply with. Thank you very much for your attention.
Thanks a lot. Thank you, Kaya. Once again, we are so proud to work with the ISI and this principles on deprivation of nationalities campaign. And we already had a joint lecture almost a month back, and we will continue to be with them to launch further events jointly. Thank you a lot, Kaya, for your excellent and details and elaboration on this case. Next, Anthony Hugh. He's representing Bahrain Center for Human Rights. He's a researcher in Bahrain Center for Human Rights. His talk is going to be about input on the arbitrary practices as a tool of silencing dissidents in Bahrain. Yes, Anthony, you can go ahead.
Hello, everyone, and thank you to Salam DHR for having us and hosting this important event. It's a pleasure to be here today. I wanted to start off by saying that citizenship is not a privilege that has to be earned. It's a fundamental human right. And as you might know, citizens consist of a minority in Bahrain and other Gulf states. And so it may be that this develops a sense among those who, perceive themselves lucky enough to claim citizenship and gain access to the rights associated with that. But nonetheless, in the past, Bahrain has used its power to revoke nationality as a way to silence dissent and activists. And what this does is two things. On the one hand, by taking away their citizenship, you take away their right to speak about national issues, to the right to participate in elections, and the right to participate in civil society in general. But on the other hand, citizenship is obviously not just about political participation. It's your ability to have a job, to travel, or even to just live in Bahrain. Like the video showed, many people were deported just shortly after their sentences were passed. And so it essentially leaves you completely without any rights. At one point in 2018, I believe the government had revoked in total almost 1,000 nationalities. And so this means in a country with about 700,000 Bahraini nationals, that's one in every 700 persons who had their nationalities and citizenship revoked. Consequences associated with becoming stateless. This practice not only strips these individuals of their right to participate politically, but it's also a way to invoke fear and scare the opposition and activists. Just last year, I believe the Committee to Protect Journalists had said that the practice was used by the Bahraini government to suppress the freedom of expression and also the freedom of press, as they were targeting a lot of journalists and bloggers who were covering the actions of the government. Also, in the past, Bahrain has been a key case study in studies about the arbitrary revocation of nationality. Many other governments in the MENA region and even in the West have used it against their citizens. Nations like the World Alliance for Citizen Participation has stated Bahrain has been at the forefront of states using this practice. So although Bahrain isn't alone in using this practice, it has an opportunity to set an example for other states that have practiced in the past or are considering or will use in the future. The second thing that I'd like to note is that what's particularly concerning nationality revocation is how it takes place. And it's namely that there's little to no due process or fair trials for those involved, at least not by international standards. In 2018, for example, there was a mass trial that resulted in over 100 citizens' nationalities, where 50 of them received life sentences. I think it's difficult for a fair trial process to take place when there are so many people being simultaneously sentenced. And as in Massad's case and many others, it's hard to believe that justice can be delivered when they're not informed about the proceedings that are happening against them. And then they have to find out that their nationalities were revoked through text, through WhatsApp, or in the media. And as Shema was saying, the overly broad language of the Bahrain Citizenship Act, its amendments have allowed the government to silence forms of opposition, dissent, and activism instead of the national security issues that it's meant to counter. For example, the law states that, among other things, that nationality can be revoked if one causes damage to the interest of the kingdom or if they committed a disloyal act against the king. And we saw, for example, this in February 2015, when there were 72 people who had their citizenship revoked. And among charges of terrorism, some of them were charged with things like defaming brotherly countries or defaming the image of the regime or spreading false news to hinder the rules of the Constitution. But in this case, more specifically, as many as 50 of these 70 people, these 70 individuals, they were human rights defenders. They were political activists, journalists, academics, or religious scholars. Only 20 of them were linked to extremist groups like Al-Qaeda or IS. And so by grouping these human rights and activists with alleged terrorist fighters, it makes a difference between what's a criminal act and what is someone just exercising their right to assembly or their right to expression. And so what this also does, it sends a message that tarnishes the images of these activists who are just seeking redress or reform. And as noted in the report, it's often a tool used in conjunction with other tools of oppression, such as torture or arbitrary detention. And all this is done simultaneously to clamp down on dissent. However, on a more positive note, international advocacy in the past has seen some successes in Bahrain. For example, in 2019, the king reinstated the citizenship of over 551 individuals, and the court restored the nationalities of another 100 individuals. And Bahrain also amended its citizenship revocation laws and restricted the power to strip nationality to the cabinet, so the king no longer has the power to unilaterally strip Bahrainis of their citizenship. And so these are all steps in the right direction, and it shows us that that reform is possible. But with that said, it's still unclear if these sentences that were passed down to these individuals were reduced, or if they were compensated for the losses that they endured during the period in which they were stateless. And as Jawad pointed out, 400 more people still remain stateless today. And according to Reuters and other organizations, these 400 individuals are mostly activists and human rights offenders. More importantly, the 500 people who had their citizenship reinstituted, their citizenship should not have been revoked in the first place. So going forward, BCHR urges the government to continue reinstating, considering the nationalities of the individuals who had theirs arbitrarily revoked, to further reform these excessively broad nationality and terrorism laws that create this culture or population of groups of statelessness. And lastly, to take initiatives to collect more information about the remaining cases of statelessness in Bahrain, to collect information about the statistics, the profiles, and the context of these various stateless groups. Because with more developed data, the government and other organizations can better understand the consequences of its policies and identify more best practices going forward. Thank you.
Thanks a lot, Anthony. And you described the process and how it was unhuman-wise, in the same times contradicting its nature with the Bahrain Constitution, the same time for sure with the International Convention. And the target was not due to any terrorist act, mainly to, as we titled this event and our report, a tool of verify that this 100 cases that they've been reinstated through the court, it was part of this 551, not additional to 551. And that was because their cases is being taken to the appeal. By the time the court was revising their case to the appeal, then they found that through a royal decree 551, they reinstate their nationality, so they have to only obey, or as we know, then the national has been reinstated. So in total, we have yet one out of almost 900 their nationality 15, and the rest 434 is still they are part of the list who are nationality has been revoked. And we think that the way international community they dealt with the first group and they pressurized the government to restore the nationality, I think such movement and such momentum and such campaigns should continue till we be sure that no citizens among any list of the revocation of nationality, and never ever nationality revocation will be used as any. We're going to hear from Devin Kani, a researcher in Amnesty International. Devin, he is in charge of MENA in general region and specifically Gulf area, where he is so close case. In general, Amnesty, they follow up the case of revocation of nationality in all this process, and they are documented it. And I can say that they had really positive steps to pressure to at least given the case under their context and so on. So now from our colleague Devin Kani. Yes, Devin.
Hello. Well, first things first, let me just make sure you can hear me.
Yes, your sound is okay. Everything is fine. Go ahead, Devin.
Okay, great. So apologies, my remarks are going to be a little bit duplicative of territory that was just covered quite well by Kaya and Anthony, because I'm again approaching this from a legal angle. In preparing my remarks, I sort of addressed myself to the question of, given that everyone present in the panel, and as is explicit in its title, sees this as a moral problem, how would you make a watertight case that Bahrain's denaturalization of its citizens is also unlawful? And just to point out at the beginning, denaturalization is maybe a sort of fancy English technical term, but it's a one-word way of saying stripping of nationality or deprivation of nationality. So it's a little faster. So I'm going to be using the term denaturalization throughout my remarks. So I would say that Kaya's remarks and the work of ISI on developing these principles are a really strong effort to establish that there are restrictions under customary international law, which would prevent most denaturalizations and Bahrain's denaturalizations in particular. I was going to come at it through the angle of treaty law, because in international law, whether we like it or not, it's unfortunately been the starting point for international law that states to consent to be bound by the rule before they are bound by it. So basically what that means is they need to have signed up to a treaty or some other legal instrument that explicitly establishes their duty and concurrent rights. So you would ask yourself, as a starting point, where can we find in the treaties to which Bahrain is a party its legal mandate in denaturalizing so many of its own citizens in this way? You'll commonly hear cited the universal rights in this context, and specifically Article 15. The second clause of Article 15 opens, "No one shall be arbitrarily deprived of his nationality." It's definitely a useful point of reference. Where it gets a little tricky is that a state that wanted to attempt to, to argue that it wasn't breaking any laws could say, this is a General Assembly resolution, it's not a treaty, we didn't sign up to it, and so therefore it's not binding international law. And to get around that, you need to go through the exercise of showing that a given rule is what they call a customary international law, which essentially means that all states are bound by it, regardless of whether or not they ever agreed to be, because it's achieved sort of a critical mass of consensus in the international community that actors see it as a necessary necessary binding legal rule that it then extends to states that that did not affirmatively join a treaty affirming whatever principle it is you're trying to show is customary law. Pretty high bar, and it can be quite challenging. So it's always nice when you can go to the lower hanging fruit and point out to a state or to its international allies, if that's your avenue of pressure, the state is violating legal obligations that it itself has recognized. So in this case, you would probably want to look first to the International Covenant on Civil and Political Rights, which Bahrain is a party to, but you would find that it's actually less than helpful on this point. The only article that directly mentions nationality in that treaty is Article 24.3, states every child has the right to acquire a nationality. So it's not quite what we're driving at with saying that people shouldn't be deprived or stripped. And this actually reflects international law on denaturalization, statelessness, right to nationality not subject to revocation. It's a little less progressive than one would wish it would be. It's to date, although this is changing again due to the work of groups like ISI, the rules have maybe not been quite as strong and as human rights protective as in other areas of human rights. But there is a treaty source that Bahrain has agreed to be bound by here. Perhaps it's a somewhat surprising source because you don't see it cited that often, but it's the Arab Charter on Human Rights, which is the regional instrument that was issued by the League of Arab States, I believe in 2004. Article 20 Arab Charter states no person may be stripped of nationality arbitrarily. That's my somewhat free translation from the Arabic. But the key word there, and that's very clear, there's not going to be any dispute about how to translate that. And Bahrain is a party to this, in addition to most members of the Arab League generally assenting to join almost all instruments issued by the Arab League. Bahrain specifically ratified this charter in Act number 7 of 2006 under Bahraini law. So it's incorporated into Bahrain's domestic law, by letter of law. It's intended to be in effect within the state of Bahrain, and Bahrain should be abiding by it and enforcing it. And that's in addition to its status as international law, given that it's a regional treaty. So again, the key word is arbitrarily. Clearly, the fact that a state or officials of a state undertake an action in the name of law or under the color of law does not automatically mean that it's not arbitrary. This is the essence of law, is the state or the official will always argue that they were acting according to lawful powers, and the argument is about whether that's credible or whether or not it was in fact arbitrary. Well, there's a couple things about the way Bahrain has approached denaturalization that paint a pretty clear picture of arbitrariness just right on their face. The first is the use of mass trials. I believe that the two largest denaturalizations in Bahrain, I could be subject to correction on this, but I think these are the largest single issuances of denaturalizations came in two mass trials. One was what they referred to locally in Bahrain as the Zu al-Fiqar Brigade's case. That was concluded on 15 May 2018, and there were 100 defendants, and 115 were denaturalized in that case. The second mass trial, where a really large number were denaturalized in one go, was what was referred to locally as the Bahraini Hezbollah trial, or one of the Bahraini Hezbollah trials. Introduced the notion that there are organizations, unclear whether they're saying it's the different instantiations of organizations under the same name, but repeatedly they've undertaken prosecutions against what they call Bahraini Hezbollah. In this particular instance, this was a trial that April 2019 2019, there were 169 total defendants, and 138 of them were denaturalized. So huge, and mass trials violate just one of the bedrock principles of law overall. It's rarely even stated in like treaty sources, but so such a groundwork that it doesn't necessarily need to be made explicit. But in criminal law, you need to prove individual liability. Collective liability won't do, and because of the way detail is lost inevitably when you scoop together a large number of people, is going to preclude an act of individual criminal liability, that this individual did this specific thing which is banned by this law at this time. You can't accomplish that level of precision with, I mean, there's no magic number, but it's already quite challenging when you have a dozen defendants in one trial, and we're talking about trials with well over 100 defendants. So that on its face, the use of mass trials to issue very large numbers, over 100 in each case of denaturalizations, is prima facie arbitrary. The second sort of ground on which you could argue that these are arbitrary and therefore in violation of the Arab Charter on Human Rights, and therefore in violation of law that Bahrain itself voluntarily joined up to and recognizes, is that they were discriminatory. Anti-discrimination is taken to be a pretty key tenet in international law. It probably is approaching, or maybe is past the threshold of being uncontroversially customary international law. You can language against discrimination, barring discrimination, is shared between both of the main human rights covenants, the socioeconomic covenant and the civil and political rights covenant. When you have shared language like that across multiple treaties, it tends to start to be a strong indication that something is gaining status as customary law. And I haven't reviewed every human rights treaty, but I'll quote here from a study by Jorun Brandvold, officer in UNHCR's statelessness unit from 2009 to 2013. She writes that the principle of non-discrimination forms a central part of all universal human rights treaties. So anti-discrimination is found in one form or another in every human rights treaty. I'll take her word on that, not having checked every single reference. But that again tells you that this is achieving customary status or is already past that threshold. So how is the Tory angle in Bahrain? Well, there's still some legwork for me to do to prove this case by case with the Hezbollah and the al-Fiqar trials. But if you ask local Bahrainis about the nature of these trials, I've been told invariably, and I think anyone else here would be too, if you broach the question, that every single defendant was Shia. When Bahrain's population is split, depending on the numbers you accept, I mean, there's at least 30 to 40% population, so it doesn't really pass the smell test right on its face that every single defendant would be a member of the same ethnicity or sect within the country. And again, you'll generally hear this said Bahrainis in the of causes that the government is saying these people were involved in, like Hezbollah, or in some other instances, allegations of ties to Iran, Sunni Bahraini would colorably be affiliated with. I'm trying to go a bit beyond that and actually demonstrate it with solid point by point, take each individual and examine their name and their locality, which are strong indicia of sect in Bahrain, and between figure it out for any given individual. I've undertaken the exercise for 2 mass trials so far. They're not denaturalization trials, but 2 mass trials, which I'll refer to as the National Day plot and the Revolutionary Guard cell cases, both in 2020. These represented a total of 91 looking at every individual defendant in these, and 90 of them were pretty clearly identifiable as Shia based on a combination of name and locality. Obviously, the ideal would be to ask the individual or their family for every instance, but not possible given the circumstances. So that's a finding of 98.9% Shia on the, prima facie. And the last case, the one case, wasn't clearly a Sunni person. It was just indecisive. There wasn't quite enough data tending to show that they were a Shia defendant for me to feel very confident in saying that's definitely the case, but there weren't contrary indications. So work through this data in this way through the method just described, but the upshot is it appears that Bahrain's mass trials overall target almost exclusively and primarily Shia, way beyond the percentage of the population that they represent in Bahrain, which prima facie is discrimination, and is a key second ground in which you could say that the use of denaturalization and mass trials is unlawful. So, yeah, those are my remarks. Thank you.
Yes, Devin, well addressed, and all aspects of it, legal-wise and within the international conventions framework, you read clearly, and for sure, such cases is still going to be under your radar, and I'm so confident that your communication either with the OHCHR or UNHCR have a very important role that you can jointly more pressure over Bahraini authorities and to act in the same time, hoping that with your efforts and the rest that we can see that reinstate of those who are still victims of revocation of nationality. Okay, we have a short terms, Ibrahim Karimi, which his case is already been elaborated in this report. Ibrahim Karimi's case is so clear and good example to indicate that how individuals have been targeted and how their nationality has been revoked, and at the same time how forcibly being out of Bahrain. And after that, we will come to our last speaker, Ioana Kozomova, and then we will reach end of this event. So let us now see together this short clip and testimony of Ibrahim Karimi.
راح أتكلم في شيء كان يخصني. طبعا الابعاد أنا أبعدوني من البحرين مرتين، إسقاط الجنسية مرتين. المرة الأولى في سنة 1981. طبعا ما كان في محاكم، ما شفنا محاكم ولا شفنا قاضي. مجرد من السجن بعد 3 أشهر من التعذيب أخذونا إلى الباخرة، من باخرة إلى إيران، وبالمنفى بحدود 25 سنة كنا بالمنفى. المهم رجعنا بعد قرابة 25 سنة، عشنا بالمضايقات من قبل الحكومة على أساس إنه الجماعة من المعارضة جايين من برا عائدين، وبقينا حتى بتنقلاتنا إلى دول خليجية كان في مضايقات. صارت أحداث 2011، اعتقلنا على الأحداث اللي صارت في 2011، وسجنت سنة. آخر السنة بالاستئناف طلعت براءة بعد ب6 أشهر ب 2012 شهر 11، مثل ما ذكر الأخ علي. سمعنا بالتلفزيون والجرايد إسقاط الجنسية. طبعا مباشرة تكلمنا مع المحامي على أساس نوكل محامي ونتحرك على الموضوع بالقضاء. طبعا لتوكيل المحامي يحتاج إلى إجراءات قانونية. رفضوا المحكمة يعطونا توكيل نوكل المحامي. وهذا الكلام راح أأكد لأخ سيد إبراهيم كيني أن اللي فادنا هو الأمنستي، بضغوطات من أمنستي على وزارة العدل، وافقوا بالنهاية أنه يعطوا التوكيل للمحامي للدفاع عنا بالمحاكم. وهذا النقطة مهمة، أن ضغوطات دولية والمنظمات الحقوقية تفيد، وهي طلبنا من جميع المنظمات الحقوقية والدولية بالاستمرار بالضغوط على الحكومة البحرينية، وهذا راح يعطي نتيجة. يعني برغم أنه سيد ديفان أكد أنه الشعارات والبيانات ما راح تفيد، بس هذا الشيء راح يفيد. طبعا احنا رحنا كل المراحل القانونية بالمحاكم عن طريق المحامي. سنة 2015 اعتقلت مرة ثانية بسبب تغريدة، وحكمت 2 وشهر. استمرت المحاكمة وبقيت بالسجن، ومحاكمتي اللي كان يدافع عني الأستاذ محمد التاجر في المحاكم طلع قرار بالإبعاد. وطبعا ما كان في موضوع التوكيل أو الكفيل كما ذكروا الأخوات والأخوة، أن نقدر نوكل أحد أو نكفل أحد يكون كفيلنا بالبحرين نبقى. ما كان في هذا أصلا، هاي الكلام ما كان مطروح يعني، ولا فتحوا لنا مجال بأن نبحث عن الكفيل. طبعا المعاناة قبل التسفير أو قبل الإبعاد يعني ذكروها الأخوة بالنسبة للعوائل، وعانينا كثيرا داخل البحرين. معاناة اقتصادية كثيرة، ضمان الاجتماعي أو التأمين الاجتماعي أو الحقوق المتبقية عندهم عند الشركات والمؤسسات وإلى آخره، هاي صارت للكل. طبعا احنا المعاناة اللي صارت أكثرها هي الاقتصادية، تمتد إلى الاجتماعية وإلى الأبناء، وتأثيره كان، أنا بالنسبة لي تأثيره كان كثير يعني على الأولاد وعلى العائلة، تأثير سلبي جدا يعني اللي أثروا فيها كثيرا. هاي لما احنا كنا بالبحرين، أنا من السجن أعطوني جنسية مكتوب فيها من سكان البحرين، صلاحية الجواز 1 سنة، وهذا ما في دولة تعترف فيها الجواز. من سكان البحرين صلاحية 1 سنة. طبعا نفوني مباشرة من مطار البحرين إلى مطار النجف، لأن ما في دولة في العالم تقبلنا. العراقيين قبلوا على أساس الوضع راح أتكلم في شيء كان يخصني. طبعا الإبعاد، أنا أبعدوني من البحرين مرتين، إسقاط الجنسية مرتين. المرة الأولى في سنة 1981. طبعا ما كان في محاكم، ما شفنا محاكم ولا شفنا قاضي، مجرد من السجن بعد 3 أشهر من التعذيب أخذونا إلى الباخرة، من باخرة إلى إيران، وبالمنفى بحدود 25 سنة كنا بالمنفى. المهم رجعنا بعد قرابة 25 سنة، عشنا بالمضايقات من قبل الحكومة على أساس أنه الجماعة من المعارضة جايين من برا عائدين، وبقينا حتى بتنقلاتنا إلى الدول الخليجية كان في مضايقات. صارت أحداث 2011، اعتقلنا على الأحداث اللي صارت في 2011، وسجنت 1 سنة. آخر السنة بالاستئناف طلعت براءة بعد ب6 أشهر ب 2012 شهر 11 مثل ما ذكر الأخ علي، سمعنا بالتلفزيون والجرايد إسقاط الجنسية. طبعا مباشرة تكلمنا مع المحامي على أساس نوكل محامي ونتحرك على الموضوع بالقضاء. طبعا لتوكيل المحامي يحتاج إلى إجراءات قانونية. رفضوا المحكمة يعطونا توكيل نوكل المحامي، وهذا الكلام راح أأكد لأخ سيد إبراهيم كيني أن اللي فادنا هو الأمنستي، بضغوطات من أمنستي على وزارة العدل، وافقوا بالنهاية أنه يعطونا توكيل، يعطوا التوكيل للمحامي للدفاع عنا بالمحاكم. وهذا النقطة مهمة، أن ضغوطات دولية والمنظمات الحقوقية تفيد، وهي طلبنا من جميع المنظمات الحقوقية والدولية بالاستمرار بالضغوط على الحكومة البحرينية، وهذا راح يعطي نتيجة يعني برغم.
As you can hear, and clearly there is another testimony who are really suffering from this revocation of nationality, Ibrahim Karimi, as he indicated. And by the way, he was my cellmate in one of the prisons. I was being detained in Bahrain. And as he indicated, he's been acquitted. Imagine someone is being under investigation with the National Security Agency for so long, and he been acquitted totally, and at the end, the authorities will revoke his nationality. Last speaker, Ioana Kuzumova, she is an academic, researcher, and member of MENA Stateless Network Steering Committee, and she's going to talk about the input on statelessness of revocation of nationality. Yes, Ioana, go ahead, please.
Hi, everyone. I think everyone can hear me.
Yes.
Thank you. So thank you so much. I'm humbled by this opportunity to conclude the launch of the report. As Jawad mentioned, I'm a human rights lawyer and a refugee lawyer, and I speak to you today on behalf of Hawiyati, the recently launched network for stateless solidarity in the Middle East and North Africa. The network briefly was established with a dual mission of, on the one hand, reducing and ending statelessness, and on the other, protecting the human rights of stateless persons in the MENA. So to this effect, it aims to engage in activities focused on the improved identification and understanding of statelessness, fostering solidarity and collaboration, and supporting advocacy. So countless and cruel euphemisms pervade how states in the MENA region treat statelessness. We know of Bidun, Maktumin, persons whose nationality is under study, those of undetermined nationality, so-called illegal residents, etc. And all of these are ways for a state to disclaim its stateless, to delegitimize their plight. So given how hard work within and outside of the region to cover up the existence of statelessness on their territories, it is remarkable that the creation of statelessness is also codified in most national laws in the MENA region, and especially so since 2011, as has been noted previously, through provisions that allow for a fully discretionary revocation of nationality. And as we have heard from Kaya and Devin, the revocation of nationality, when done without regard for the affected person's possession of another nationality, often results in not just for the individual whose nationality is revoked, sentence. And this form of hereditary or inherited banishment runs against every notion of human rights. And to the extent that revocation of nationality is permissible, it requires careful and searching analysis of the consequences of such measure. So as has been articulated in Principle 5, of the principles on deprivation of nationality as national security measure issued by ISI, an assessment of whether deprivation of nationality will render a person stateless is neither a historic nor predictive measure or exercise. The question to be answered is whether at the point of deprivation, the individual is considered by the competent authority of any other state as a national under the operation of its law. And this is a question for the to examine. And we have heard, and much more eloquently than I could ever express, that inflicting statelessness as a result of the revocation of nationality is a punishment. The testimony we have heard, in my view, is proof beyond reasonable doubt. But this acknowledged as early as 1957 by the U.S. Supreme Court in Trump v. Dulles, statelessness is the total destruction of the individual status in organized society. It is a form of punishment that more primitive than torture, for it destroys the individual the political existence that was centuries in development. So this is a widely shared, so that it has become a commonplace for those of us in the field. But I repeat it to you today because it carries the biting and as yet unacknowledged truth. Revocation of nationality to the Middle East, but has been one of the issues motivating the creation of COEAD, Business Network for the Middle East and North Africa, and on whose behalf I'm here today. We in COEAD believe that the creation of intra-regional dialogues and alliances across diverse groups can strengthen the project to eliminate statelessness and shine a light on nationality revocation. Over the course of the last year, the individuals and organizations united by COEAD have seen hope in the voicing of experiences and in a clear articulation of principles and recommendations. We seek to bring together communities, activists, and organizations whose voices are to be amplified so as to correct the forcefully advanced by states across the region, such as Bahrain. Our voices, I believe, are needed to propel measures, such as the recent efforts on part of the League of Arab States to create a regional action plan for the prevention and reduction of statelessness. The need for a regional action plan and for its corollaries, national action plans, is acute and it's overdue. So instead of concluding today, I would like to encourage everyone watching us to use their voices and platforms to remind members of the League of Arab States of their commitments under the Arab Declaration on Belonging and Legal Identity, passed in 2018.
Thanks a lot, Ioana, and well addressed. For sure, I'm going to repeat your message to all those who revocation of nationality or they are already stateless due to different reasons, really to depend on the international mechanism, and they can coordinate with all concerns, either through the communication with treaty bodies and the rest of the UN human rights committees and so on. Almost we have 10 minutes, so I have a question to each of our panelists. Start with Shaima. If everyone can answer to the question with very brief answer within 2 minutes maximum time. Shaima, they say that there are enough international, local local bodies, local human rights bodies like ombudsmen, National Institution for Human Rights, and so on. So all of them, they say that why you don't approach them, why you don't try to defend you, and so on. So how you evaluate this claim that the victims can approach such institutions in Bahrain?
In the international sphere, when it comes to international law, it's always actually kind of it's always more favored for a person to go through local legislation first before they go into international legislation, just for the sake of time and for the fact that more local legislation would be more contextualized for them. But overall, as Bahrain is a member of the international community, and because of the fact that it also has obligations under international conventions that it willingly joined, then those obligations must be sure to be met, and Bahrain itself has to be held accountable. And so a person can't only just, especially in a state, in a place where it might seem that not a lot of human rights bodies are actually separate from the government or anything like that, there needs to be a bigger person out there that can kind of like provide you for those rights. So for anyone, it's like if you could submit both locally and internationally, it would be good either way. But definitely there are international obligations that Bahrain should be held accountable for. And those obligations or those international conventions offer a wider range of human rights that aren't even submitted or given to people in the local context.
Next question to you, Kaya. As I know, you have a very good and strong relationships with so many UN treaty bodies, some special rapporteurs, at the same time, UNHCR. How you think that such coordination could be totally positive for defending the victims? In the same time, I Belong campaign, which we think that through that one, more attention has been given to the issue of revocation of nationality, but at the same time on the issue of the statelessness internationally.
Thanks so much, Jawad. And yeah,
yes, go ahead.
The treaty body system, and we've noticed that there's still. Can you not hear me? I'm sorry. Yes. Okay. Then let me continue with my answer. So the treaty bodies are a very interesting framework, and we've been looking at this framework more elaborately, and not least through our new database on nationality and statelessness, in which we've been trying to compile records relate to nationality and statelessness, and also specifically to deprivation of nationality, to get a better understanding of what the playing field basically is already at UN level within the treaty bodies and within the system of universal periodic review. And we've seen that with the limited bodies that we've now covered, that deprivation of nationality is actually an issue as compared to some of the other issues. So statelessness is actually doesn't come up as often. So there's still real work to be done to create awareness around the issue of nationality deprivation at the UN level, which is one of the things we hope to do within our year of action against citizenship stripping, but also continue to do, of course, beyond that, and always happy to cooperate with anyone who's interested in submitting to the bodies. Of course, the UNHCR I Belong campaign has been very important in raising awareness of general issues, statelessness, a little bit also around deprivation of nationality for sure. So it's really great to see that this is also, and as part of the broader international framework, the UN statelessness are obviously a very important tool to address nationality deprivation. Thanks so much.
Yeah, thanks a lot, Kaya. And next, you, Anthony, what is recommendation and advice either to the victims in Bahrain or abroad for them to document their case or to approach international community and so on? So what is your advice to them in this regard?
So for victims of denaturalization, I think with regard to local engagement for these human rights bodies that you had mentioned, BCHR had actually recently published a report that analyzes 4 of these human rights bodies, such as the National Institute for Human Rights, the Special Investigation Unit, and we found that there is still a culture of impunity that's pervasive within these human rights bodies, even though their creation was a positive step forward. And so because of this, I think international engagement is still very important. We saw that in the past there have been successes as a result of many governments and many international organizations, international institutions that had all put pressure behind during this policy of denaturalization.
Devin, as I believe Amnesty in early years had a visit to Bahrain, and you met with some victims. In the same time, authorities in this regard. What you hear as a response from the authorities? Do you are in contact with them, and what they say about their decision to revocate nationality? In the same time, can you see any hope at this at this issue, where possibly that some action will be taken, positive action to the rest of those who their nationality has been revoked? Devin?
Yes, so the first part of the question was with respect to our Amnesty's
your contacts with the authorities, in Bahrain, and ever you got any positive reply, and what is your evaluation of the way they dealt with the case, and if there is any hope that maybe they will revise such decision once again?
I don't know that we've ever addressed specifically, like bilaterally, rather than through a public statement, denaturalization or stripping of citizenship, but we definitely do try and periodically raise cases with them through, the channels that they and us, mainly the British, are constantly emphasizing should be used, which are private approaches to the National Institution for Human Rights. What you can say is that they're happy to be in correspondence, but I can't really recall a time that we've had a substantive success from engagement with them. In one instance, we asked if a detainee who was a minor, a juvenile under 18, could benefit from the provisions of the new domestic law, which created or elaborated a juvenile justice system. Bahrain should have had that in place many years ago, a proper juvenile justice system that exists as part of its treaty obligation. 90s, they only just set it up. So we asked if a child who had been detained prior to the enactment of the law, the new domestic law, which was decades late by international law, could benefit from the provisions of the law, and they just passed over that in silence. They didn't implement that, and they didn't give a response as to why they weren't going to or speak to it at all. And similarly, the other instance was we recently asked the NIHR, the National Institution for Human Rights, if they could share figures on the number of infections with COVID at Jau prison, because this has been a major issue of concern for families of detainees in Bahrain, and there was a huge gap between what had been officially acknowledged, which was just 3 infections, and quite reliable information that families had that the actual number was approaching 100. And in that instance, they said, we will get back to you with the number, and we haven't received the number. So yeah, there haven't been huge successes on that front.
Thank you very much. My last question to Ioana. Ioana, now we have now a good chance to find out the Hawiyati or MENA network status. They can be a very active player in this region. What is your recommendation for the NGOs that they can adopt a certain types of the campaign advocacy, and how they can be in closer contact with you as a MENA Stateness network that they can be part of your advocacies and so on. Please make it short. We have almost last 2 minutes. Ioana?
Thank you, Jawad, and thanks everyone. So at present, Hawiyadi can be found on our social media platform, and we are very happy to interface with any regional and national NGOs that are interested in contributing to this work and coordinating policies with us. We are at Hawiyadi on Twitter, and I believe that we can share our social media outlets. As far as recommendations, I believe that developing statelessness and finding ways to the fact that statelessness is pervasive across the region is important, and yet it has been incredibly difficult for many NGOs operating out of the region and out of the Gulf specifically. So we are very much happy to brainstorm with anyone interested in taking up statelessness reduction and elimination across the Middle East, and hope that we can continue the struggle together. Thank you.
Thanks a lot, Ioana. At the end, first of all, what we address today as in this event, it is like a continuation of the efforts, it's continuation of the campaigns, continuation of advocacies, and at the same time, collaboration with the rest of the international, regional, and local NGO who are addressing the issue of revocation of nationality. And at the same time, we will continue to have similar reports that, like the one we launched today, and for all our efforts, going to have a positive impact to resolve this issue. Let me thank Shaima and Kaya, Anthony, Devin, and Ioana for all your excellent participation, and looking forward again in coming event. And for sure, thanks a lot for all the audience and who all supported us to launch this report and have this excellent event. Thanks a lot and good